Good afternoon. It is Tracy B. Excuse me one second. The divorce solutionist here for Thick of It Thursdays. Um, I am going to pick up where I left off last week. Excuse me, where I was talking about custody agreements and or parenting plans. Depends on where you are. It's how it's referred to. But I'm going to use those terms interchangeably because, again, they pretty much serve the same purpose. Some courts require a parenting plan to be submitted as soon as one party asks for custody or asks for a modification of custody or visitation. Um, a lot of courts don't, but some courts do, and they have their own form. So, and they usually refer to as a visiting plan, parenting plan, access plan, co-parenting plan. They're all the same thing. It's all used interchangeably depending on what jurisdiction you're in. Again, everything that I talk about is merely for the United States because I don't. I have access to the laws of the United States, but not any other country. So this is just for the United States. Sorry, Canada, Mexico. Anyway, I don't really remember where I left off at last week. I'm looking at a list of things that are usually included in parenting plans or custody agreements. And I don't know if I mentioned, but I'm going to mention this week. So and I did a blog about this actually. This week's blog is about provisions in custody agreements or parenting plans that can be controversial. Controversial in a sense where a lot of courts or judges do not want to allow them in agreements because of a variety of reasons. It could be just against public policy. It could be, something customary practice in that particular jurisdiction. It could be a lot of reasons. The blog, unfortunately, I couldn't post it today. I don't know what happened to my website. I'm trying to get someone to help me figure out what happened, but the blog should be up by this evening or by tomorrow. It's usually up Wednesday evening, but I was having this technical issue, and I'm not a tech savvy person, so I couldn't figure it out. So I'm waiting for a response back. But for those of you who want to know a little bit more about that, you can go to my blog. Not today. I'm gonna bet safely instead tomorrow instead. So anyway, most parenting plans and custody agreements usually do have some standard language, some standard provisions in all of them across the board, because even though each state has their own set of values and standards and factors to defining the best interest of the child, nationally, they all have the same objective, and that is to maintain the well-being of your child or your kids, mental, physical, emotional, and intellectual well-being. So anything that falls under those guys is the court is going to either promulgate rules, practices, et cetera, et cetera. So that's why some provisions are standard because they meet those elements, and then some of them are not because what may work in Washington, the state of Washington, not the capital, may not work in New York. So some, because of logistics, whatever. So because of that, some provisions may be customary because they fall under that umbrella of what's in the best interest of the child, but they may be nuanced because, again, some things don't work in Washington as they do in New York or vice versa. So anyway, some common stipulations. So I think I did a live or a blog on joint custody, and that topic comes up a lot. Joint custody comes up a lot, and it should, because now I think all states, with an exception of maybe a few, have either some sort of presumption of joint custody or they order joint custody. But it's rare where you'll see a state that has nothing on the books or in case law that has to do with awarding joint custody. That's the basic the starting point in custody cases. They want parents to have joint custody. And I've been getting a lot of, oh, I live in a mother state, so I have sole custody. Oh, I live in it doesn't work that way. You have sole custody, either one, because first of all, sole custody is something that's awarded by the court. You don't get sole custody by default. There's no such thing as sole custody by default. Either you're awarded it by the court or the other parent is just non-existent. He died or whatever. But you don't get sole custody by default. If you try to apply for your child's passport and the dad's name is on the birth certificate, and you say, oh, well, the dad is not in his or her life, I have sole custody, they're going to ask you for a court order saying that you have sole custody. So, and that's my point. That's a legal terminology. You don't have sole custody because the dad is not involved. You may have presumed custody because dad is not on the birth certificate, but all dad has to do is go to court and seek paternity and get an acknowledgement of paternity, and then he may get some sort of custody. You may get sole custody depending on the circumstances, but that's a legal term. So I wanted to clarify that. So the only way you can get that is through a court order. And every state differs as to what is required to meet the standard for sole custody. That's not an easy accomplishment. That's not an easy feat. That's not something that's just handed out, sole custody. It's not. Again, it's because the presumption is joint custody. That's the starting point. They're going to presume the moment you have kids and you walk into a courthouse to file for custody or visits or whatever, they're going to presume joint custody. And the burden is on either parent as to why it should not be joint custody. And that's what I mean by presume. The presumption is, it's like they're going to assume that joint custody is best for your child or your kids. And the burden is on whomever is seeking anything but that to prove why it should not be joint custody. Now, to deviate from joint custody, there's things like domestic violence, abuse, abandonment, things like that. Those come into play to get the court to award you sole custody. Even when you have sole custody, though, that doesn't mean access is denied. That's another thing people tend to think. They tend to think sole custody means the other parent gets no visits. That's not how it works either. That's not an automatic. Okay. And you can get sole custody by default if the other parent never shows up to court. So you serve them with the petition and the summons to show up to court for custody. They never answer it. They never show up. They never appear. And you're asking for sole custody. Boom. There you go. You got sole custody by default. Okay. So joint custody is something that's going to be presumed. And so most states that have their own forms for custody, they will have a provision in there for joint custody. If after a hearing or a trial and proof evidence that suffices for the court to prove why joint custody should not be awarded, then they may issue sole custody with, like I said, access or visitation to the other parent. And that means days, weeks, overnights, whatever have you. If there is no, if it's, clear that there's no reason for joint custody, of course, that won't be in the stipulation, but it will say either sole custody to mom with primary physical custody and joint decision-making with dad. And I'm not being biased. I'm just using mom because, most of the time it is mom petitioning for custody. Or it can say joint custody with primary physical custody to mom and joint decision-making or joint legal custody to both parents, blah, blah, blah. I don't want to get into too many of the variations of it because it's a whole nother hour in and of itself. But I just wanted to bring that up because that is going to be one of the things included in your custody provision, how custody is determined and decision-making. Decision making is very, 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 very important. And I see a lot of people don't cover that part in their agreements completely. If you have joint decision making, which is okay in some circumstances where the parents, some people can co-parent, some people literally can co-parent and they can make decisions jointly. But there's a lot of times where that doesn't happen. Specifically, I'll give you an example, this COVID thing. I've seen so often parents fighting over whether or not their kids should go back to in-school instruction or to continue virtual schooling. And they had joint decision making. So who wins? Does the kid go back to in-school instruction or do they stay home and continue virtual schooling? That's why it's important, even when you have joint decision making, if your agreement, if the judge strong arms you into having joint decision making in the agreement, include who it should be the final decision maker, whether it be you, whether it be the other party, or whether it be a third party. The third party can be a parent coordinator, a mediator, a friend of the court, whatever it is. But include that, because it defeats the purpose to have joint decision making if you guys have a decision to make and you're at an impasse. You're going to have to go back to court to file a contempt or a violation or an enforcement. And now you're talking time and money, and it can be actually moot, because if they've already either enrolled the child in school instruction or taken a kid out, either way, the issue is moot because it's already been done. So to avoid that, include that last part. Final decision making should be some judges may make you say, in the event that there is a disagreement or we are unable to agree on a legal decision regarding our kids, final decision maker should be blah, blah, blah. Okay? That helps a lot. Traveling with kids out of the state and especially out of the country. That should definitely be included, especially for families who have roots or families in another country. That's very, very important. You don't ever want to get caught up in an international kidnapping or what is the statute? Oh, I forgot the statute. I'm drawing a blank. Excuse me, it'll come to me. You don't ever want to get caught up in trying to get your kid back from a different country, the Hague Convention. That is the most expensive, time-consuming, emotionally draining circumstance to be in. So it is advisable, particularly for kids who are either born outside of this country or who have a parent who has strong ties to another country, that you include stipulations about traveling domestically, but definitely internationally. Definitely. And it should be clear who is to have or apply for the kid's passport. Some judges, depending on your concerns, your legitimate concerns about the possibility of your kids being kidnapped to another country, some judges will order that a third party hold on to the kids' passports for safekeeping. They call it holding in escrow. It can be held in escrow. There's other measures you can take, to ensure that your kid doesn't that doesn't happen. Like, I think you either notify the State Department and they put the kids on a list. They don't stop them from traveling, but it's like an alert. There's some other things, but again, that's another topic for another day. But definitely put stipulations about traveling. Who can travel with the kids, for how long, when the other parent should be put on notice about the travel, who are they traveling with, et cetera, et cetera, et cetera. Those things should be included in your agreement or your plan. This is something that I see come up a lot too. This has come up quite a bit actually lately. The kid has visits with dad or mom, and the other parent, the parent who's not having the visit, don't know the address of the parent they're visiting with. They don't know. So if there was an emergency and they had to, pick up the kid for whatever reason, they wouldn't know where to go because they don't have an address. That's split. Me personally, I would never let my kid go anywhere where I don't know the address. But I have seen, in my years of practice, I have seen judges tell the custodial parent, you don't need the address. You don't need the address. There's no concern. There's no safety issues. You don't need the address. You don't need to see where they live. You don't need to see where your kid is going to be spending time. And, a lot of times when that has happened, it was usually for a sound reason. Either the custodial parent was harassing the non-custodial parent, popping up, unexpectedly, micromanaging, being controlling, borderline stalking, being manipulative. That's usually when the judge will say, you know what, you don't need to know that. At me, as a law guardian or guardian ad litem, as some of you refer to, I would always tell both parents that both parents should be made aware of any addresses that the kid would be spending the night at, not just spending the day at, but if they're going to be spending time like overnight, then yeah, they should exchange the addresses. Childcare. Someone asked me the other day, could she take her child out of childcare, even though the parties agreed to childcare? That's something that should be in writing as well. That should be included in the plan. Why? Let me tell you my philosophy about childcare. And I've had parents say to me that this is crazy, and I thought their response was crazy. Childcare is something that should be well planned and well thought out. I don't think people should just, and if I sound entitled, I'm sorry, but I don't think people should just, randomly decide to put their kids in childcare. I'm being honest. I don't think for me personally, not necessarily professionally, but personally, when I had my son, I prepared to stay home with him for the first 3 years. Again, I apologize if I sound entitled. And I'm saying this for a reason. Some people think like me. I had a child. I decided to stay home. I wanted to stay home. When I decided to put him in childcare, his dad and I talked about it. We agreed. So, and it was a discussion. It was a discussion about me staying home. It was a discussion about me putting him in childcare as well. We agreed, and we discussed all the possibilities, the responsibilities, all the implications, everything. So to agree to put your child in daycare and then to turn around and say, well, you know what, I want to take him out, and you think there's no problem, there's no issue, it could be. It could be. It depends on what your beliefs are, what your philosophy is about that. I personally did that because those are the tender years. I wanted to be home with my son so that I can influence him, so that I can teach him, I can expose him to what I wanted him to be exposed to. Again, if I sound like an elitist, that's not my intention. Trust me, when I did it, we we lived on almost nothing, but that's the sacrifice I was willing to make. So, and I'm saying this to say, when you agree to put your kids in childcare, you make that as a collective agreement. Again, depending on what your reasonings are, your values, or your beliefs, or whatever, to change that unilaterally can pose a problem. So it's ideal to include that. You should include when the child should go to childcare, what age. Again, that's another thing. Some people don't believe in pre-K 3, 4. Some people just want to send their kids straight to kindergarten. That's something that should be included in the agreement, because it can create all kinds of conflict unnecessarily, because that's often overlooked, and it shouldn't be. You should discuss it. You don't have to be like me. You can decide the moment maternity leave, paternity leave is over, that you're going to put your child in childcare because you don't have a choice. That's fine. My point is you should discuss it and agree on it. And when circumstances change, that should be included in the agreement as well. Under what circumstances can we change the daycare situation? That's not something that should be done unilaterally. And if someone came to me and asked me to help them file a modification petition for that, I would definitely talk to them about that. And I would say, you know what? This is serious. Some people think it's not, but it is. It is. And there are law guardians and guardian ad litems and attorneys and judges who feel exactly the way I feel. Another provision that is definitely important is the communication between the parents. Communication between parents. If you're high conflict, if there's the history of abuse or DV, domestic violence, I always say DV, and someone asked me the other day, what is DV? But it's domestic violence. Excuse me. If there's a history of that, if of any kind of abuse or even substance abuse, alcoholism, whatever, and it just makes communication difficult, include the specific parameters in your agreement as to how the communication should go. There's so many apps now, Talking Parents, Our Family Wizard. There's so many apps now you can communicate that way. Me personally, with my son's dad, we communicated through email. It was court ordered that he can only communicate with me through email, and it worked fine for me. But again, it should be explicit. It should be very, very clear, very clear. And you can get as specific as including the time limit. That communication should be limited to the anything related to the kids. Like I said, either email, text, apps, Skype, WhatsApp, whatever it is you choose. And again, any deviation from that is considered a violation, and it should be. Yeah, sorry about that. I'm getting all these beeps and messages. I'm so sorry, but it distracts me. Let me think. Let me see if I have more here. I think I discussed last week pickup and drop-offs, who can accompany the parties for pickup and drop-offs, communication, calls and video chats. What else did I discuss last week? Oh, this is a big one as well. And again, this is going to vary depending on your family. But this was an issue in my personal family, and I see it often in others, is the access to tablets, phones, blah, blah. This is usually for the bigger kids, like 8 or 9 and up. That should definitely be included as well. Access to phones, tablets, the games, because I think now you can communicate through the games, through the game systems. That should be covered as well. Mainly because what kids will do, they will use that as a basis to prefer one parent over the other. And there's other ways they'll do that as well. But that's one that I professionally think should be addressed. Because not only that, you're talking about, access to both parents when, unlimited access, and that's not fair. If one parent is enjoying their visits with the child or the kids, and the other parent incessantly texts or video chats that child, that's not fair, and vice versa. That's not fair. So limiting access to those devices, some parents go as far as taking them. I don't know about that. That depends on your family dynamics and your structure. But you should definitely be specific as far as that's concerned. You should include that. You should at least discuss it. And some of these I'm talking about, at least bring them up and you'll decide amongst you and the mediator and the parenting coordinator or the judge or whomever is involved, the GAL, whether or not these issues are something that you need to address. But you should at least discuss that, not address, but to include. But you should at least talk about them. Let me see if I can come up with a few more. I'm gonna try to come up with a few more. Let me just look for a second. I think I mentioned the morality clause last week. I don't like the morality clause. That's the clause that says, you know, your ex isn't allowed to have, someone of the opposite sex or a romantic interest around your child unless they've known each other for 6 months, blah, blah, blah. I don't like that because it, first of all, works both ways, but then it gets really iffy. Who determines whether or not that person is a romantic interest? Number one. Who determines how long, they've been, a romantic interest? When did they cross that line? Were they friends and then they became romantic, and at what point? And number three, who's going to monitor that? Who has time to monitor that? How are you going to monitor that? How are you going to go into a courtroom and prove to a judge that your ex has been having a romantic interest with this person for 6 months in front of your kid? Like, how are you going to prove that? What evidence do you have to prove that? You can document all you want, but you have to have some objective evidence to prove that. And how are you going to do that? So I don't even like morality clauses. And I see so many people now, like, they want it. And I'm always like, you don't want it. And they all fight with me. And I'm like, you know what? We'll do it just to placate them. But it's a headache. And and some judges won't do it. Some judges will not do it. They won't, because of the same reasons I just said. Sharing information, school information, health information, doctor information, mental health information, extracurricular activities information, blah, blah, blah. Again, some jurisdictions require a sharing of information. That's the standard. Some don't. I think it should be included because if both parents are active in the child or the kid's lives, then why not? Then why not? You not wanting to share the information, why? What purpose does that serve? Whether they do anything with it or not, if they're an active parent, then why not? Right? At the same time, both parents should be, the school should know that both parents are active, and that should be included in the agreement as well. If both parents are active, then the schools should know that both parents are active. They should have both parents' contact information. And if I'm the GAL, I'm always going to advocate for that. Unless there's, again, everything I say, there's always an exception. Domestic violence, abuse, blah, blah, blah. And I don't mean alleged. I mean proven, reported, indicated somewhere. That's what I have for now. I'm going to leave some. I'm going to do part 3 because next week, what I think I'm going to do is I'm going to upload a sample parenting agreement, and I'm going to actually figure out how to show it, how to display it. And so that if anyone has any specific questions about language or wording, they could ask that during next week's live. So I think I'm going to end here. If anybody has any questions, please feel free to answer. Yes, Robin, we were talking about custody agreements and parenting plans, if you're still present. Sorry, I'm just finding your comment. Anyway, my groups, I think I mentioned I have a new group, Pro Se Divorce and Custody. I'm still working on a lot of material for that group. I'm going to put a lot of free resources in that group, but it's really, really time consuming. I'm thinking about hiring someone just to do it for me, because I really want that group to be a resource for pro se litigants to come and be able to find exactly what they're looking for. It's going to take a minute. It's going to take a while. I'm not going to kid myself to think I'm going to do that overnight, because it's a labor intensive feat, but I'm going to do it. But anyway, you could still join, because I do post different, I have a different theme every day, and I do answer questions there. That's specifically for pro se litigants, though. The ones who aren't pro se, or even if you are, I have a divorce glow up. And that one is a little bit more, this is where I do my live. That one's a little bit more geared toward those who need some help with strategy. They may have a lawyer and they just need some help with strategy, or coming up with a strategic action plan, or things like that. So that's the other one, the Divorce Glow Up. My website is thedivorcesolutionist.com. My Facebook page is The Divorce Solutionist. I offer pro se coaching now. I offer divorce and custody coaching for pro se and represented litigants. I do unbundled services, document preparation, document review and organization. I draft documents for you. I look at documents for you. I interpret documents for you. I even do uncontested divorce forms for you. I do research, case law research, judge research, process server, private investigations, background searches, and I think that's it. So if you need any of those, please feel free to visit my website at thedivorcesolutionist.com, or send me a message on my Facebook page, The Divorce Solutionist. Just send me a message there, or WhatsApp there, and I will respond within 24 hours. Right now, I'm working on so many things. I'm still working out the details on my membership, my monthly membership subscription-based program. And I had so much happen between November and January that it's like I'm so far behind. But please bear with me. Please, please, please bear with me. Feel free to reach out to me and ask me questions. I do give free 15-minute consultations, and I do those via video chat so that I could see your beautiful faces. You could schedule that at you could go to my Facebook page, The Divorce Solutionist, and schedule it from there. Anyway, until next week,